Have you ever wondered if you truly have control over how companies use your personal data, even after you have given it to them? The General Data Protection Regulation, commonly known as GDPR, indeed provides individuals with a robust right to object to the processing of their personal data. This means you can tell an organization to stop using your data in certain situations, putting power back into your hands regarding your privacy. The GDPR addresses the right to object primarily through its Article 21, establishing various grounds upon which an individual can exercise this right. One key ground applies when data processing is based on the performance of a task carried out in the public interest or in the exercise of official authority, or when it relies on the legitimate interests of the data controller. Here, the individual must present specific grounds relating to their particular situation. Another significant aspect is the absolute right to object to processing for direct marketing purposes, meaning no justification is needed from the individual. Finally, objections can also be raised against processing for scientific or historical research purposes, unless it is necessary for a task carried out for reasons of public interest. Exercising this right typically involves making a clear, unambiguous statement to the data controller that you object to their processing of your data. While there is no prescribed format, it is advisable to communicate your objection in writing, detailing the specific processing activities you are objecting to and the grounds for your objection, if applicable. The data controller then has 1 calendar month to respond, and they must either cease the processing or demonstrate compelling legitimate grounds that override your interests and rights, or for the establishment, exercise, or defense of legal claims. For direct marketing, the controller must stop processing immediately. A key legal concept underpinning the right to object is the shifting of the burden of proof. When an individual objects on grounds related to legitimate interests, the onus is on the data controller to prove that their legitimate interests override the individual's fundamental rights and freedoms. This is a high bar, reflecting the GDPR's emphasis on data subject rights. Furthermore, organizations are required to explicitly inform individuals about their right to object at the point of first communication, often highlighted in privacy notices, ensuring transparency and accessibility of this critical right. Ultimately, the GDPR's right to object empowers individuals with a vital mechanism to challenge and control how their personal information is used. It transforms data subjects from passive observers into active participants in their data governance, ensuring that processing activities align with their fundamental rights and freedoms, especially when legitimate interests are invoked, or for direct marketing where the right is absolute.